This action arises out of a slip and fall in a fast food restaurant owned by the defendant. Following a jury verdict in favor of the plaintiffs on the issue of liability and a mistrial on damages, but before a new jury could be completed or empaneled to hear the damages portion of the case, the defendant moved pursuant to CPLR to set aside the verdict on the issue of liability as a matter of law. The motion already had been made orally to the Supreme Court at an earlier point in the proceedings, at which time the court reserved decision and requested submissions. The Supreme Court granted the defendant's motion, set aside the verdict, and dismissed the complaint, finding that the record contained no evidence that the defendant created the condition and insufficient evidence on which a jury could find that the defendant knew or should have known of a dangerous condition and failed to remedy it. It is well settled that before a court can conclude that a jury verdict is not supported by sufficient evidence, it must first find that there is simply no valid line of reasoning and permissible inferences which could possibly lead rational people to the conclusion reached by the jury on the basis of the evidence presented. To establish a prima facie case in an action to recover damages for personal injuries caused by a slip and fall, the plaintiff must prove that the defendant either created the condition which caused the accident or that it had actual or constructive notice of the hazardous condition and a reasonable time within which to correct it. Cohen versus Hallmark Cards, 45, New York 2nd, 493, 499. See, for example, Goldman versus Waldbaum, Incorporated, 297, Appellate Division 2nd, 277, McGuire versus Southland Corporation, 245, Appellate Division 2nd, 347. Here, the plaintiff did not contend that the defendant created the condition or had actual notice of it, but relied on constructive notice to prove their case. To establish constructive notice, a plaintiff must demonstrate that the dangerous condition was visible and apparent and existed for a sufficient length of time before the accident to permit the defendant to discover and remedy it. See, for example, Denver versus Winthrop University Hospital, 272, Appellate Division 2nd, 431. Accepting all the evidence offered by the plaintiffs as true for the purposes of this motion, and according them the benefit of the most favorable inferences that can be drawn therefrom, see Alexander versus Eldred, 63, New York 2nd, 460, 464, the Supreme Court properly concluded that any finding that the condition was present for a sufficient period of time before the injured plaintiff's fall to enable the defendant to remedy it would call for speculation. In an action to recover damages for personal injuries, the defendant's third-party plaintiff and the third-party defendant separately appeal from an order of the Supreme Court, Richmond County, dated December 14th, 2007, which denied their respective motions for summary judgment dismissing the complaint, ordered that the order is reversed on the law with one bill of costs payable to the appellants appearing separately and filing separate briefs. The motions are granted and the complaint is dismissed. The plaintiff allegedly was injured when she slipped and fell while exiting a bathroom in a building owned by the defendant, third-party plaintiff, and operated by several related subsidiaries, which are also defendants' third-party plaintiffs. The bathroom was maintained and cleaned by the third-party defendant, American Building Maintenance Corporation, hereinafter American Building. The plaintiff claimed that she slipped on water which had accumulated on the bathroom floor. The defendant's third-party plaintiffs and American Building separately moved for summary judgment dismissing the complaint. The Supreme Court denied the motions, and we reverse. The movants established their entitlement to judgment as a matter of law by relying upon the plaintiff's deposition testimony and that of someone who arrived at the scene of the accident shortly after the accident.